Imagine trying to design a single set of rules for a user base of over 1 billion people, speaking hundreds of languages spread across a massive subcontinent. To keep a population that large organized, accountable, and democratic, you need an ironclad operating system, a baseline framework that everyone agrees to follow. For India, that operating system is the Constitution. It was built from the ground up by the Constituent Assembly, a group of elected representatives who debated and compiled the foundational code of the new republic over an extended period. The result is highly precise. Rather than a set of vague guidelines, it is broken down into 395 distinct, numbered articles. The entire system launches with a mission statement, the Preamble. It explicitly defines the objective of the nation, establishing India as a sovereign, socialist, secular, and democratic republic. Because of its immense size, reading the document randomly can be overwhelming. But if you read its numbered parts sequentially, you are watching the exact logical steps required to boot up a nation. Before you can assign rights or pass laws, you have to define the physical space where those rules actually apply. This map shows the exact boundaries in Part 1. Article 1 establishes the legal identity. India, that is Bharat, shall be a union of states. But boundaries aren't static. Parliament has direct authority to form new states or alter existing ones. Defining the territory first creates the physical and legal foundation upon which the rest of the government structure operates. Once the hardware is built and the borders are set, the system needs to identify its users. Part 2 handles this by laying out the strict framework for determining Indian citizenship. With the users identified, Part 3 activates their core protections. These are the fundamental rights. They act as strict constitutional limitations on state power, designed to protect individual liberty from government overreach. These protections guarantee that the state cannot arbitrarily treat similarly situated people differently, ensuring equality before the law under Article 14. They also secure the protection of life and personal liberty under Article 21, establishing that no person can be deprived of either without a procedure established by law. Rights are useless without enforcement. Article 32 gives citizens the direct ability to approach the Supreme Court if those fundamental rights are violated. The court can then issue specific writs, legal orders like habeas corpus, to demand immediate justification for a state action. By placing these protections immediately after citizenship, the framework structurally prioritizes human dignity, ensuring the government is bound by individual liberties. If Part 3 outlines what the government cannot do, Part 4 outlines what it should do. These are the directive principles of state policy. Unlike fundamental rights, you cannot take the government to court if it fails to implement these principles. Instead, they act as built-in constitutional guidance, setting long-term targets for social and economic governance. They instruct the state to actively work towards goals like equal justice, early childhood care, and the protection of forests, wildlife, and the broader environment. To execute these massive policy goals, the Constitution constructs specific institutional machinery. It starts at the executive level, with Article 52 officially establishing the office of the President. It then moves to the legislative branch. Article 79 constructs the Parliament, creating the bodies where policies will actually be debated and written into law. To prevent a monopoly of power, Article 246 systematically distributes legislative authority, clearly defining exactly which subjects the central union government can control and which fall to the individual states. By defining the territory, identifying the citizens, securing their rights, setting policy goals, and constructing the legislative machinery to execute them, Parts 1 through 4 build the complete operational architecture of the Republic. A strict, unyielding legal code written in 1950 faces an obvious problem. If it cannot respond to shifting social and economic pressures, it will inevitably crack under the weight of modern society. The framers anticipated this, so they engineered a survival mechanism directly into the document. Article 368 provides a highly specific procedure for amending the Constitution. This mechanism allows Parliament to patch the code, adding new articles or omitting outdated ones. The document evolves to solve new problems, while its core structural integrity remains intact. We can see this adaptability in practice with the 106th Constitutional Amendment Act of 2023. This update actively modified the text, inserting brand new articles into the legal framework to mandate the reservation of legislative seats for women in specified legislative bodies. The legal framework behind India's democracy functions at an incredible scale. It works not because a group of drafters perfectly predicted the challenges of the 21st century, but because they designed a system capable of adapting to them.